So Brigitte Amiri, I use she, her pronouns. I'm the Deputy Director of the ACLU's Reproductive Freedom Project. I am primarily a litigator, and I've been at the ACLU for almost 18 years. Generally what we did before, I'll talk a little bit about kind of what our model for litigation looked like. Before Roe was overturned, the months leading up to the Dobbs decision, kind of where we are now and where we expect things to go. And then I really just want this to be a conversation. I want to hear from you, answer your questions, and have a discussion, and hear your thoughts as well. For years, really what we did at the ACLU, the National Office, and the Reproductive Freedom Project is when a state would ban abortion or restrict access to abortion, we would challenge the law in federal court, hopefully get it blocked. Our primary goal was to keep clinic doors open in various states and ensure people could get care. We also did some access to contraception and some other reproductive freedom issues, but abortion access has been primarily the main focus of our work for many years. So when we saw that the Supreme Court took Dobbs versus Jackson Women's Health Organization, a case out of Mississippi brought by the Center for Reproductive Rights, about whether a 15-week ban was constitutional, that in and of itself instilled fear in our hearts, because if it is settled for 50 years that there is a constitutional right to abortion under the federal Constitution, why would the Supreme Court take a case presenting this question that is well settled? So that is the first signal that something is not right with the state of the world. I mean, obviously, Trump also vowed to appoint Supreme Court justices to overturn Roe versus Wade. So there are, various things along the way that are concerning, including the litigation in Texas around Senate Bill 8. I was a member of that trial team where Texas passed a law saying that anyone who provided an abortion after 6 weeks in pregnancy or helped someone get an abortion after 6 weeks in pregnancy in Texas could be sued by anyone in the country for basically a bounty, a minimum of $10,000 in damages. This is another interesting procedural question, which is when anyone in the country can sue you, who do you sue to block the law? And so that was the fundamental question in that case. And we lost in the Supreme Court basically the ability to block the law because there was no government enforcement actor to then bring a lawsuit to get an injunction against that law. So that was also like another clue that things were going south in terms of the constitutional right to abortion. And then December 1st, my friend and colleague from the Center for Reproductive Rights, Julie Rickleman, argued the case. And if you have not listened to her argument and want a master class in appellate advocacy, she did an amazing job, as did the Solicitor General of the United States, Elizabeth Prelager. And it also just goes to show you that despite the best advocacy, you can still lose. So the questions from the justices did kind of reflect the ultimate decision. And so there were some clues, obviously, at oral argument that there were enough justices to overturn Roe versus Wade. So at that point, we started preparing for what are we going to do? We have these long-standing clients in various states: Kentucky, Arkansas, Alabama, Ohio, West Virginia, all of which had immediate threats to abortion access on the books, either trigger bans, statutes that would be triggered if Roe was overturned, pre-Roe abortion bans that existed on the statutes, these zombie statutes that were never repealed, that would come in to have some effect, or other laws, bans at 6 weeks in pregnancy, for example, that we had blocked under the federal courts, and if we lost Roe, we would not have the ability to keep our injunctions in federal court. So we started preparing for different decision scenarios and what we were going to do to ensure access to abortion and protect our clients and their patients' ability to access abortion. And then the decision in Dobbs was leaked in April, and that also just added more fuel to the fire that we better get our ducks ready for an alternative. And so lo and behold, on whatever day that was, June 26th, you never know when the Supreme Court's going to issue decisions, and so you kind of have a guess that the blockbuster cases, the cases that are very big, will be decided at the end of the court term, which is usually at the end of June, but you actually don't even know which day in June you're going to recess. So basically, for those final days in June, we had plans in place for each client, depending upon the landscape of abortion, laws in their state, and they're hitting refresh on the SCOTUS website for the decision to come. And the day that it came, that morning that came, there were a lot of very large swear words that came out of my mouth, and then I had to skim the opinion. It was very similar to the leaked opinion. And my very first order of business, there was not a lot of time to cry or scream or to do anything other than call my clients in the states that had immediate bans and tell them they had to stop providing. So my first call was to my beloved client in Kentucky, EMW Women's Surgical Center, which is the only independent abortion provider in Kentucky, and for a while the only abortion provider in Kentucky before Planned Parenthood was allowed to provide in Louisville. And I had to say, and we have this plan in place. Roe's been overturned. The trigger ban is now arguably in effect, and you need to stop providing abortions, and you need to turn all the patients away. And so the staff was in tears, the patients were in tears. They had a waiting room of people that day who had been consented for their abortions, signed the paperwork, thought they were getting their abortions, and then they had to be told, I'm sorry, we can't see you because the Supreme Court just overturned Roe, and the Kentucky Attorney General is threatening to enforce the trigger ban right away. We already had papers ready to go under the state court, under the state constitution in Kentucky, as well as some other states. After Dobbs was decided, those of us who litigate on the national level, the ACLU, Planned Parenthood, Lawyering Project, the Center for Reproductive Rights, I think we have filed 14 cases in state court under the state constitution to restore access to abortion, and Kentucky was one of them, and we had our papers ready to go. So within a couple of days after the Dobbs decision, we're in state court under the state constitution arguing for the first time ever that the Kentucky Constitution protects the right to abortion under the right to privacy and the right to self-determination in the state constitution. Within a couple of days of filing, we get a restraining order from the circuit court judge restoring access to abortion and allowing EMW to call the patients that they had to turn away and say, please come back. And we can see you. Within 5 days that they had to shut down, they turned away 200 patients that were either in their waiting room, had already been consented, or called for appointments. And that's just five days in the immediate aftermath of Dobbs. After we got the restraining order on an emergency basis, we headed into a temporary injunction hearing, an evidentiary hearing, that we had 4 witnesses, 2 on our side and 2 on their side. And in the meantime, the Attorney General in Kentucky tried to take an immediate appeal of our restraining order to the Kentucky Supreme Court, which is actually not permissible under the rules. So we were briefing this emergency appeal of our restraining order in addition to preparing for an evidentiary hearing on July 6th. We got a great decision from the circuit court judge blocking the Kentucky 6-week ban and trigger ban, continuing to restore access. We had access in place for about a month in Kentucky before one Court of Appeals judge on an emergency basis took away our temporary injunction. The Kentucky Supreme Court took the full case over from the Court of Appeals, refused to reinstate our temporary injunction, but said, we'll hear arguments in this case, but we're only going to hear them 1 week after the election. And that was critical to some of the justices, as they explicitly said, because on November 8th, there was a ballot initiative in Kentucky, and the voters were going to decide whether to remove constitutional protections from the Kentucky Constitution for abortion. So the Supreme Court justices are looking to see what happens at the ballot to see to schedule their argument. So, as you may have seen from the election, I guess I've been talking too much over these last 3 days. I talked her out. We won all the ballot initiatives that were on the ballot on November 8th. Kentucky, my home state of Michigan, California, Vermont, and Kansas back in August. And so this is huge. This is just a huge amazing victory at the ballot box, and also goes to show that all of the tools in the toolbox are needed. The litigation can stem the tide of some bad things happening. The policy piece of it is incredibly important, also to stem the tide of bad things and also to push progress forward. The grassroots organizing on the ground in all these places was amazing and so critical. And so we won at the ballot, allowing us to go to the Kentucky Supreme Court to have our case heard, which was on Tuesday. So I was there for argument on Tuesday and before coming straight here. And I have to say the arguments went fairly well. We don't have a decision yet, but it was really interesting, and you can watch them on YouTube. Also, as I'm on the airport coming here, we get a decision in our Georgia case. I had been to trial in our Georgia case October 25th and 26th to block Georgia's 6-week ban under their state constitution in state court. And we got a 15-page opinion from the judge on Tuesday blocking permanently the 6-week ban under a legal theory, a word that I had never heard of until just recently, that the law was void ab initio. So the law was passed in 2019 at a time when Roe was still the law of the land. And any law under the state constitution in Georgia that is passed that is clearly unconstitutional is void on arrival. It is just a dead letter. And so that was one of our legal arguments, which the judge accepted, permanently blocked the law, and said, if the Georgia Supreme Court disagrees with me on this, I'm prepared to make factual findings after if the case gets back down to me and decide the right to privacy claim. So I will stop talking. It's a patchwork of states right now. About 14 states have bans in place. There's constant changing. Every day there's something different in terms of a state restoring access, a state maybe losing access, and so it's a mess. And chaos was by design to confuse people about their rights and where they can access abortion. Things are bad. The devastation of people who are denied wanted abortions cannot be overstated in terms of what it means for their lives and their bodies and their families, especially for people who are in the most marginalized communities. The Black maternal mortality rate in this country is abysmal, especially in a lot of these states where there are bans. Forcing people to carry their pregnancies to term against their will actually kill them, disproportionately Black women. Also, people who live in rural areas, young people, people who don't have the ability to travel because they don't have documentation, because they can't get past a checkpoint, a CBP checkpoint. These are all people who will be forced to carry their pregnancies to term at great consequence to their health and their lives. And if the other side has their way, we will see a national ban on abortion, and that's exactly what they're going to try to push next, and we've already seen glimmers of that. Just because you are in Massachusetts or New York or California and think, well, my state is going to protect access to abortion. The other side has the next vision, which is either a federal constitutional amendment prohibiting abortion, a recognition that fetuses are people for the purposes of the 14th Amendment by the US Supreme Court, a congressional ban on abortion that would ban abortion nationally that would be upheld by the Supreme Court. And obviously the other attacks on reproductive freedom, the right to contraception, and other privacy rights like LGBT rights are also implicated by the Dobbs decision. So things are bad, they're going to get worse before they get better. But if we do nothing, they're going to continue to get worse, and they will never get better. So every day I go to work, I love my job, I love what I do. As bleak as it is sometimes, and as hard as it is, I do what I do because it is so meaningful for people to make decisions about their lives and their bodies, and we just have to keep going, one foot in front of the other. So I'll stop there, and happy to hear your thoughts and questions.
This is an adjacent topic, but for my wife and I, the Dobbs decision has been very concerning, and we're both wondering what would it look like for same-sex marriage to be overturned by the Supreme Court? Like, what are the red flags that we should look out for?
Yeah, so I think if the right to same-sex marriage is overturned by the Supreme Court, I think it will return to the states, and so depending on what state you are in, and also there's the national bill. I've not been following the news very closely, but there's the federal bill to ensure the right to get married. So I think it depends on what state. If the Supreme Court were to take a case that overturns the right to gay marriage, I think it would depend on what state you're in, and also it would depend on what the protections are in this new federal bill.
You were talking about the Georgia constitutional amendment, is that what?
The Georgia constitutional provision, the void ab initio.
Yeah, so
Yeah.
if it did end up coming back to that lower court after going to the Georgia Supreme Court, how would that lower court judge argue on right to privacy if that's what the Supreme Court overturned?
Yeah, so so the most of the state court cases that we have brought, all the state court cases we've brought, we are making an argument that the state constitution protects the right to abortion separately and independently, and sometimes to a greater degree than the federal constitution. So you don't need the federal constitution to argue for the right to privacy under the state constitution. And in many of our cases, we bring multiple claims. And if we win on one claim and that claim goes up to the higher court and we get reversed, we still have our remaining claims that we get to try to get relief on. And so the judge, the circuit court judge, or the county judge in Fulton County in Georgia said, I'm just deciding the void ab initio claim. This is an easy legal claim. This law was clearly unconstitutional, was passed, it was dead on arrival, it was void. But on appeal, which I know the state's gonna appeal, and they already have, if the Georgia Supreme Court disagrees with me, then there are these remaining claims that the plaintiffs have brought that we've already had a trial on, send the case back to me, and I'll decide their remaining claims. So it gives us like multiple bites of the apple.
I'm just curious if you could talk more about what it looks like to try to plan a national litigation strategy when it's like, on one hand, you have all of these like laws that are coming into effect that, like you said, you're trying to stem the tide of, but then also looking forward when, you know, it's likely there's now going to be a bunch of litigation that's going to come up around contraceptive use and like IVF and all that sort of stuff. So I'm just curious if you could talk a little bit about how that is playing into your work.
I think the technical legal term is it's a shit show. It's hard to plan. You can't plan. You just have to be really nimble and so and draw on the various things that you have seen in the past as potentially predictors for the future. But even that, it's really hard to do. And luckily at the ACLU, we have this multidiscipline, multi-issue organization that we can draw. I can virtually walk down the hallway and talk to my LGBT colleagues or my speech privacy and technology colleagues and get their input on things and work with our national political and advocacy department as well. But I think we're tracking things like the legislative sessions and the bills, like in Missouri and South Carolina, we've already seen bills that would prohibit people from leaving their home state where there's a ban to go to a state where abortion is legal to obtain an abortion. Or to help someone with that travel. And so we're like, okay, the right to travel, the constitutional right to travel is going to be important, so let's start digging into that. And so you look for clues happening. There was a leaked conversation between an anti-abortion group and lawmakers in Tennessee saying, next you need to focus on bans on contraception and bans on IVF. And so we're like, okay, that's another clue, like put that onto the list. So I think that's kind of, it's a little bit catch as catch can and trying to figure out what to do. And we're in crisis mode and we're really just doing damage control and trying to alleviate some human suffering. And that is not to say that we don't also then think about the world that we want. We also have to be thinking about Roe is just the floor, it was never the ceiling. Roe is what didn't mean anything to some people because it was just a right that existed on paper and because they couldn't access abortion where they lived. And so we have to get beyond the Roe panacea, because it wasn't one, and think about true reproductive freedom, access to abortion, contraception, the right to parent, in a country that is free from police violence and with a climate that isn't going to kill us. So all of those things, I think you have to push to that vision and also try to just do the triage. It's hard. I think I saw a hand back here next,
Yeah, I guess this is sort of more of a personal question for you, but could you speak to sort of your journey through law school and how you got involved in reproductive freedom and justice and kind of your path toward your current role?
Absolutely. So I had the good fortune of graduating from this fabulous law school, and I do love this law school so much. And I really do think I would have probably dropped out of any other law school because law school is hard. My first year is really hard, and it's hard to see kind of beyond what your life looks like when you're in 1L. But the co-op process is also amazing. And this is another reason why I love the school. I would not have the job that I have today had it not been for the co-op program. I'm first generation to graduate from college. I didn't know any lawyers growing up. I I knew I wanted to use law as a tool for social change, but I didn't know exactly what. And the co-op process lets you experiment with different things, see what you like to do, and also make connections and prove yourself. So I did 4 co-ops while I was here, one at the Massachusetts Teachers Association, one at Legal Services in Chicago, one for a plaintiff's and employment discrimination attorney, and one at the Center for Reproductive Rights. And when I was at the Center for Reproductive Rights, they apparently thought I was doing a good job, and they said, we've got a fellowship, you should apply for the fellowship. And interestingly, I'll say this now because the person no longer works here, I think, in career services. As I'm doing my postgraduate applications, she said to me, don't even bother applying to the fellowship at the Center for Reproductive Rights. They're never going to hire you. You didn't go to a fancy school, you didn't do a clerkship, and you didn't do a fellowship. And I was like, but I did a co-op there, and they told me to apply. So I didn't listen to her, and I applied. I mean, she was right, I didn't get the fellowship. But they did offer me a 6-month contract. And they said, if you want to move to New York, take the bar, see if you passed. And I also did have a permanent job from the legal services in Chicago as well. And as well as like kind of some short-term offers from my other co-ops. So I took a kind of a gamble, and I was kind of afraid to move to New York City, and I didn't know anyone there. And but I went, and I was there for a few months, and one of the fellowship attorneys became pregnant. She, exercising her reproductive freedom, decided she was not coming back after her parental leave, and so the Center for Reproductive Rights put me in her fellowship slot, and I got to be at the center for about 3.5 years. They ran out of funding for me. I applied for permanent jobs, also did not get hired for them, and I needed to leave, and I went to South Brooklyn Legal Services doing foreclosure prevention for low-income homeowners. And I had this economic justice career for 2.5 years, which was amazing, and I learned so much, but also learned that I get very burned out on the direct services model, and repro is also really where my heart is. And so the job came open at the ACLU in the Reproductive Freedom Project in 2005. And they called literally everybody I worked with at the center, and luckily they said good things about me, and then that's how I got my job. It's hard. If I had $1 for every cover letter and resume that I sent trying to find a job, I would not maybe be a rich woman because of inflation, but I would have a little bit of a piggy bank to do something fun with. It's hard. It sounds very easy now. I can tell the path, and it sounds easy, but it's not easy.
I think maybe with my limited understanding of how this whole thing worked out, I understand that with Dobbs, a lot of the arguments in most of the states is that there is now these state legislations that have created like the trigger bans. And so when you're litigating against these or trying to ask to remove these bans, saying they're unconstitutional due to the state constitution, what are the further arguments that they're saying? Because a lot of I feel like the narrative is very moralistic and a very like personal, but I believe that beyond that, there has to be some legal standing for what they're arguing. So I was wondering where they're bringing that from.
Yeah, I mean, you would hope and think that they had real legal arguments, and sometimes they do and sometimes they don't. I mean, I think, you're absolutely right that a lot of this stems from the religious belief that life begins at conception, and then the state adopts that view and says we have a state policy of ensuring that our laws protect every human being from the moment of conception, and we, as a policy matter, get to make that determination in the legislature, and the court can't disturb that. So that's one of the big arguments that Kentucky, for example, is making, that the courts don't have any role in adjudicating the constitutional question because the General Assembly is the policy-making branch that gets to weigh the competing interests, and they have decided that life begins at conception and that and therefore abortion should be banned. They also have said that there is no right to abortion in the Kentucky Constitution, for example. The word abortion does not appear in any constitution that I'm aware of in the United States, in any of the states. And also they say that based on the history of the leading up to the Constitution, in the constitutional debates, abortion wasn't mentioned. So it's these historical arguments about how you establish a right, and that historically they argue there isn't a basis. They're wrong. There is. I mean, they're not wrong that the right to abortion doesn't appear in the Constitution, but that's true of so many other rights. And in Kentucky in particular, there is a very strong right to privacy that the Kentucky Supreme Court has recognized in several cases, including a case about same-sex sexual relationships that was decided after Bowers versus Hardwick when there was no federal constitutional right to same-sex sexual relationships, but the Kentucky Supreme Court said under our Constitution, we have a stronger right to privacy, and we're going to strike down our criminal ban on same-sex relationships. And so we're relying on that case, for example, to say like this is a logical extension of that. And interestingly, to your point, the circuit court judge, we didn't bring a religious freedom claim, but the circuit court judge on his own said for the state to adopt the belief and make policy that life begins at conception, which is a religious belief that not everybody in Kentucky shares, they are violating the state equivalent of the Establishment Clause of separation of church and state. So that's just a little sample. The briefs are all on our website. If anyone's curious, you can dig in and read the briefs and watch the YouTube argument presented by my fabulous colleague Heather Gapner at ACLU Kentucky. Yeah.
I know the ACLU has a few pieces of commentary on the decriminalization of sex work. I'm wondering if sex worker justice intersects with your project at all, and if so, how?
Yeah, it's a good question. We are fairly siloed at the ACLU, so I get to draw on the expertise of my colleagues down the hall, but in terms of like the actual work, we're pretty much, I'm like pretty much all abortion all the time.
I was wondering, so just sort of strategically, how does it work in terms of where attorneys are barred with this being a national project? Like, how do you get everywhere?
Yeah, it's a great question. So I'm licensed in New York and in some federal courts, including appellate courts in the U.S. Supreme Court. And then when I go to state court in Kentucky, for example, I get to file a motion for pro hac vice, which is a motion specifically designed to allow me to practice just in that case. And I have to be sponsored by a local attorney and submit my certificate of good standing from New York saying that I've never been disciplined and do an affidavit. So I get admitted just for the individual cases in these different states. Yeah.
I was wondering if you could talk a little bit more about the role of the historical arguments in the Dobbs decision, because, reading Justice Alito's opinion when he talks about, language from the 13th century and stuff, how does that weigh against, the doctrine of stare decisis or any of that?
Yeah. I mean, it's, I think it's this idea that our constitutional rights under the federal constitution can be found either only in the text of the Constitution or in some sort of long historical look back has to be false, because there are so many other constitutional rights that exist that don't have either of those things, just like the right to abortion. And if you take the premise that either there has to be explicit textual support for a constitutional right or this longstanding history, then so many other rights are up for grabs. Interracial relationships, the right to contraception, obviously. It just cannot be that is how we're going to make decisions about our constitutional rights. And the stare decisis arguments, the stare decisis is for suckers, is the strict scrutiny podcast catchphrase, and there's very clear reliance interest. This has been the law of the land for 50 years. This is the first time that the U.S. Supreme Court has taken away an existing constitutional right. It's just disingenuous. Here and then here. Sorry. Yeah.
I was wondering if you could talk about the Jewish challenge to the Kentucky abortion under the First Amendment.
Yeah.
Fighting it on First Amendment religious grounds.
Yeah. So a group of women, their primary claim in that case, they brought first in state court and then they got removed to federal court, saying that they want treatment for IVF. They may be in some sort of process along the way of their IVF treatment, and they're concerned that the Kentucky abortion bans will impact their ability to grow their families under IVF. And they have made a number of claims. They're Jewish women saying, I don't believe that life begins at conception and I want to be able to grow my families, and the abortion ban is threatening my ability to do that. And so they have not filed for an injunction, but have filed their case, making these allegations, and it's still pretty new in terms of the case. And some of these arguments are existing around the country, not just with IVF, but also with other abortion bans under the State Religious Freedom Restoration Act as well. And again, they're still really early, and there's one pending in Florida, there's one pending in Indiana, and I think it's a little too early to say how they're going to pan out. But I think it's important for people to reclaim the mantle of religious beliefs and what it means to want to have reproductive freedom based on your own beliefs and your own autonomy.
One more question over here.
Okay,
I was just gonna ask kind of how you navigate advising clients in an area of law where it is so, like you mentioned with Kentucky, like going back and forth, when there's like real world impacts on patients and like maybe they don't have a day off when the law is like deemed, like how do you navigate that with such a need-based patient base?
Yeah, it's really, really, really hard. It's the short version, and especially because we don't know when courts are going to make decisions. You have to turn on a dime. Like when the Court of Appeals took away our injunction, and we knew that the case was pending, but you have no idea which day the court is going to rule. And so you do your best to, talk to your client and say, like, you may want to tell patients coming in that, this is pending, and so you may decide that you may want to go to a different state. And that this is something that is on the horizon. So you try to work with the client and figure out kind of what's going to work. But it's really, really, really hard, and it's been devastating for patients who have been turned away at the last minute, haven't been able to travel, and have had to be forced to carry their pregnancies to term.
Great, well, thank you so much. It's really great.